Hey everybody, welcome to a Notorious POD. I'm really excited for this episode. You know, I'm generally excited about most of my episodes, but this one in particular because I have a very special guest with me to talk about some of the legal issues that, you know, as we have been sort of discussing on Notorious for a long time, that have been really confronting the industry. And I do believe this guest is the most impressive guest I've ever had on. Let me just quickly read his bio before I bring him in. This is Professor Scott Hemphill. He is the Moses H. Grossman Professor of Law at NYU Law School, where I actually am an alum. And he's the co-director of the Engelberg Center on Innovation Law and Policy. Scott received a PhD in economics and a JD from Stanford, where he graduated first in his class. He also holds an AB from Harvard and an MSc in economics from the London School of Economics, where he studied as a Fulbright scholar. Hemphill clerked for Judge Richard Posner on the U.S. Court of Appeals for the Seventh Circuit and Justice Antonin Scalia on the U.S. Supreme Court. On public service leave from academia, he served as the Antitrust Bureau Chief for the New York Attorney General's Office. He is a member of the American Law Institute and a consultant for REX, the Austin-based digital real estate platform. Let me bring on Professor Hemphill. Scott, how are you?
Good, great. Thanks for having me.
Yeah, so like I said, that's the most impressive bio I think I've ever read. Maybe with the exception of Justice Whizzer White, who also played in the NFL.
I definitely don't have that going for me. No.
You don't have some professional sports or
not even close.
Yeah. There's a F1 driver in the spare time. Nothing.
I wish. That would be awesome.
So before we begin, I guess just real quick, is there anything that's not in your bio that anyone should know about you? That's the most impressive list of things, but
father of two kids.
There we go.
But otherwise, you've said it all and then some.
There we go. All right. So once again, thanks so much for coming on. I just thought, you know what, we were talking to our mutual friend Mike Toth from REX. I thought there are all these legal cases, and I think this is going to really tremendously affect the future of the real estate industry. Mm-hmm. And he said, you should talk to Scott because he is one of the acknowledged experts in antitrust law in the country. And I know you've been working with those guys for a little bit, so you have a little bit more of a background understanding of what's been happening in the residential real estate industry. I guess we should all assume there's a certain amount of bias that we can kind of infer from the fact that you are a consultant for REX. Is that fair?
I wouldn't cop to bias. I mean, I definitely have a point of view, but it's certainly true that I've been helping them with their case, and so your listeners should hold that in mind as we talk.
Take that into account. All right.
Take that into account, sure.
Okay, so right off the bat,
just to be clear, I'm also going to speak for myself. I'm not purporting to reflect their views.
Of course, and it's safe to assume you're not speaking for NYU. You're not speaking for any other organization. These are all
no.
You and my opinions about these important topics. All right, so
there we go.
Because most of my audience are not lawyers, right? Can we just start with just a real high level, perspective? Like, what is antitrust law? What is the purpose behind it? And then why? Yeah, let's go from there.
Yeah, great. So, antitrust law can be thought of as a way of organizing economic activity, as a way of protecting rivalry, as the best way of achieving low prices, high quality, and innovation.
Right.
And so, antitrust law sets rules of the road that all of us have to follow as individuals, as companies, even nonprofits have to follow the rules to make sure that they neither agree with rivals or suppliers or with customers in a way that harms competition, or that they act in ways that entrench their dominance, that put a moat around themselves or make the moat higher, or maybe I should say deeper, stronger, against new innovators that might try to come in. Okay.
So with that framework, with that context, have you read those cases that are pending against NAR right now? The Moehrl versus NAR, Sitzer, Leeder.
Yeah. So I confess there are so many cases right now. I don't promise to have read all of them, but I am familiar with the the unbundling cases that you started with, like the Moehrl case,
Right.
and of course with the case that Rex has brought against Zillow,
Right.
and I'm aware of the government's recent consent decree with
Right.
NAR. So
Right.
that gets me up to 4 or 5. I might be missing 1 or 2 in there, but I have some familiarity with those.
There's a Conti versus SFAR is the latest one that I saw. But let's just kind of look at it as an antitrust legal expert. Again, understand you're not a judge, you're not one of the attorneys like involved with the case directly. What's your take on Moehrl and those unbundling cases, Sitzer? I mean, do the plaintiffs have the chance?
Yeah. So, would it be all right if I just take a step back a little bit?
Let's take a step back. Yeah.
Right. So, what is it that we're worried about from an antitrust perspective? What is it that sort of brings us here with these cases for which Moehrl is an important example? I think there's a couple aspects of the market that are naturally going to attract the attention of regulators like DOJ and also private parties looking to bring antitrust suits. One, let me just talk about 3 features if I can for just a minute, just kind of set the table.
Of course.
So I think there are 3 aspects that are really important here. First, judged kind of over time and across countries, the fees look high to an outsider. This 5%, 6% fee feels high, in part because it's high, in part because it hasn't varied much, in part it hasn't varied over time, even as the work needed to, certainly on the buy side, maybe on the sell side too, has gone down, even though house prices have gone up, right? So this persistent percentage is pretty unusual. Not perfectly unique to residential real estate, but unusual and suggests that you're going to get some attention. Second, there's a structural feature that's pretty unusual, which is this disconnection between the level of payment made to a buy-side broker and the value. So one party is making the decision about the level, and the other party is actually experiencing, that is, the buyer is experiencing the value that a broker provides. Typically, whatever we pay, is also for something that we get. So the idea of having someone else set the price and pay it, in a sense, and then we get the value, that disconnect creates some opportunities for mischief, I think. And then the third feature that's important is this highly collaborative nature, right? I mean, brokers are helping to make possible a transaction between a buyer and a seller. And these repeated interactions over time make the market vulnerable to anti-competitive conduct. For example, shunning a price cutter, right? That's a classic kind of punishment, and it's particularly available when you consider that, if a sell side offer to the buyer's broker is low, the buyer's broker could steer away. And that makes it harder for innovation or even price cutting to take root. So all of these things combined have painted a big target, I think, on the residential real estate industry. This has been true for decades, right? These new cases are not the first cases that involve NAR, certainly. We've been in this for a long time. And so I think that brings us to Moehrl. Because, I think Moehrl squarely targets this blanket unilateral offer of compensation to the buyer's broker. That's a core part, I think, of the MLS NAR story. And, where are we at this stage? The district court has, denied dismissal, recognizing that, as alleged, there could well be an anti-competitive effect here. That is, that the prices could be too high because of this disconnect that I mentioned, because of this steering possibility, may be accentuated by this misleading impression that buyers are left with that that they're not paying something. Of course they're paying something, because it's compounded into the price. I think everybody understands, that pays attention here, that buyers are paying via the price of the
they're the only one bringing cash to the table.
Right. Yes. No. That's that's right. So right. That's right. So one should always be suspicious of assertions of a free lunch. And here, like most places, that free lunch turns out not to be free. And so this kind of case, kind of call for unbundling, is a classic antitrust issue. I mean,
So what would be like the closest analog, like historically, other cases, like this around unbundling that you've seen that you think would be the closest analogy to what we are seeing with Sitzer and Moehrl?
Yeah. So the analogy that came to mind as I was thinking about this is not a straight antitrust case, but it's a regulatory case.
Okay.
So what I'm thinking of when I think of this is unbundling that we see the Federal Trade Commission doing, for example, in contact lenses. So so contact lens, and there will be distinctions that one can draw, just to be clear, right? Like this particular market is highly unique in certain respects, and so any analogy that we draw, we're going to be able to say, okay, there are actually some important differences here. And so I don't want to like overstate the analogy here, but when we think about contact lenses, you go to an optometrist or an ophthalmologist, and you get a prescription. Mm-hmm. Now, you might imagine that the optometrist would like to sell you contact lenses while you're there,
right?
And maybe at a high price. And so for a long time, optometrists were free to require you to also buy
contacts,
your contacts when you got your prescription. But the FTC came in and through something called the contact lens rule, they unbundled these two things. Same thing is true for eyeglasses, mm-hmm. where your optometrist is required to give you the prescription, and you can take it anywhere you want. You can take it to 1-800-CONTACTS, you can take it to Walmart, you can go any place, right? And what this does is free up competition by unbundling one piece of the payment or one thing that's being offered from the other thing. Mm-hmm. And so the analogy here would be that the seller's services and the buyer's services would be entirely separate and separately acquired.
Right.
Now, this is not, just to be clear, exactly the same as unilateral offer of compensation. But what it shares is this fundamental idea of unbundling as a key to unlocking competition mm-hmm. in a business.
Okay. So I have the opportunity of having legitimate world-class expert in this. So I wanted to throw out a couple of things that I've personally have seen, within the industry, or either said, or there were comments where realtors and brokers and others sort of, object, right? And I sit there and like I've written articles, I've written posts around, Moehrl, around Sitzer, all these things, and invariably there's somebody in the comment section like, well, they don't understand what's going on. I'm like, look, man, like I'm not the court. Go make your arguments to them. But I want to sort of like bring their defenses, if you will, and see what your take is on. The first one that I hear most often is, why is this even a concern to the seller? Because really, the claim is the seller has agreed to pay 5% or 6% to the listing broker to sell his house. What the listing broker then does with that money afterwards, why is that the seller's concern at all? Why is this an anti-competitive thing at all? It's just natural market forces. So in other words, the claim is, it's not that the listing broker is going to the seller saying, I won't charge you 3%. The listing broker is going to the seller saying, I will charge you 6%. And then what I do with my 6% is up to me, not up to you. This didn't change the pricing. It didn't change anything. Like, what do you think about that argument?
Well, I guess I'm struggling to understand it a little bit. I mean, I think it sort of sits to one side of what we're really concerned about. What we're concerned about is a contractual setup that might have the effect of thwarting competition, right? I mean, just keep our eye on the prize here. What we want to see is vigorous competition between buy-side brokers for a customer's business. Mm-hmm. And obviously we have some competition, right?
It's fierce.
Folks work their tails off to acquire leads and bring home transactions. So I don't want to be heard to say that there's no competition. That's obviously not the case. But you can have competition along some dimensions and yet still not have full and fair competition. So imagine the old days of airline regulation where prices were basically fixed by the government.
Right.
That doesn't mean there was no competition. They would compete over, fancy lunches and sandwich quality and so forth. That isn't competition of the most valuable kind, though, when price competition is being thwarted. And so even though we have some competition, we don't have price competition. And so the question then is, are there contractual arrangements that are standing in the way of full, free, fair price competition? And this unilateral offer of compensation has that tendency,
Right.
because it's creating this disconnect.
Right.
So I sort of feel like this idea, we spent the 6%, it's our business, what do you care? Well, I mean, we care because that has the predictable effect of limiting competition on the buy side. And if we care about competition on the buy side, and antitrust sure does care about competition on the buy side, we have to think about how contracts are standing in the way of that.
Got it. Okay. So the second part of that then is this, right? Which is clearly, and I've written this, I think these lawsuits all turn on the question of steering. Do buyer agents really steer their clients away from homes that are offering less, right? Is this a widespread problem, or is this a real small, tiny minority, like 1% of the time, or is it more like 60% of the time? I mean, I think it's going to be fact dependent that way. So I suspect a lot of the expert testimony and whatever will be around that topic. Having said that, one of the defenses is steering is illegal and it's against the code of ethics. Like NAR literally says you should not steer your clients. If you do, this is an ethical violation. So how is NAR being sued?
So I don't have my own independent view of the degree to which steering happens out in the wild. I mean, obviously it happens some of the time. Whether it happens a lot, whether it happens a little bit, I imagine that's the kind of thing that will be revealed in discovery.
Exactly what I'm thinking. Because there's already some academic studies that show steering is pretty significant, but there's no.
And we should expect. I mean, we should expect to see some steering. It would be natural that that would happen. I do want to suggest, though, that even if the level of steering was relatively low, this disconnect between who's making the payment and who's actually receiving the value, can create a competitively problematic outcome. Now, there are other ways of helping, right? Like you can imagine other tools at our disposal that could help reduce this problem, could help increase competition on the buy side. Rebating being the most obvious of those. Sure. And of course, rebating happens. Sure. Doesn't happen a ton, right?
And we're going to get into that case, because I want to ask you about that.
From an economist standpoint, you might think, gosh, there should be a ton of rebating. When I bought a house, I didn't seek a rebate. And so, I understand at some practical level that one doesn't always go and do that. Right. You don't want to be your broker's least favorite customer either, right? I mean, right? I mean, it's an emotionally laden transaction. Right. Like, kibitzing with your broker about what the right level of compensation is like not the easiest thing in the world to do. I do think that policy strategies, legal cases, litigation, that encourage buy-side rebating can make a difference. And this is just to say, I think there are other tools beyond this litigation that could help introduce additional competition, I should say, on the buy side. But even if there wasn't much steering, it could also be the case that there's not much competition on the buy side, even absent the steering issue.
Oh, what do you mean? Why would that be? If there's
because on the sell side, there's not going to be some strong incentive to be the one. What is the sell side's incentive to cut the buy side commission, even if there's not much steering, right?
Because then I could offer lower prices and I gain market share, right?
Could be. Yes, you might be subject to shunning. Folks worried about retaliation might still set those fees at a relatively high level, understanding that the seller may not be paying so much attention to this to think, oh, what I really want to do is try to reduce the buy-side commission from 3, let's say, to 2, or from 2.5 to 1.5, in order to hold on to a little bit more of the economics.
Right. So I guess what I'm wondering is this: had there ever been cases where, because of shunning, because of boycotts, because of these things, even though the entity being sued has rules that says you cannot do boycotts, you should shun people, we want open price competition. The entity says that, but the members, you know what I mean, like actually engage in this unethical, illegal behavior. Has there been cases where the entity is still held responsible?
That I understand where you're going.
Yeah.
I don't have. It's like 0 for 0. Like I don't have cases in mind on either side of that particular twist.
So that could be a novel issue potentially presented by this case.
Yeah, could be. The example that just occurs to me is imagine you entered a price fixing conspiracy with your rival, but you also had a rule on the books that said, but don't talk. It's strictly the case that one should not talk to their rivals.
Right.
I don't think that would be a good defense. That on the one hand you did this thing that was flagrantly illegal. On the other hand you told them not to do it.
Right.
That would feel like a fig leaf. Mm-hmm. Or even if well meant, it wouldn't be seen as a complete defense.
Okay.
So it's a cute point, but I don't know that it's a decisive one. But like I said, I don't have a case exactly like this to rely on.
So before we move off of this, again, just your opinion. If you, and again, because you know the antitrust cases, you know the judicial kind of thinking around this, who do you think wins? If you had to take a bet right now, who do you think wins, plaintiffs or the defendants?
Yeah, so I don't feel close enough to the litigation to be able to give you a solid answer on that, except for the following. I mean, I think when all is said and done, it is often the case that compelling facts matter more than the niceties of antitrust doctrine, which from the start, for a long time anyway, have permitted a fairly open-ended and wide-ranging examination by the court about the economic effects of particular conduct. So if you have compelling facts, I think often that matters to outcomes. And I think that the argument that the unilateral offer of compensation has bad competitive effects, that strikes me as pretty strong. I've not seen a compelling response on the economics.
All right.
And so at the end of the day, I think that the fairly open-ended antitrust inquiry that the court will be engaged in would suggest liability, putting to one side all of the little traps that antitrust doctrine places in the way of liability.
Right.
I also do. On this issue, I also do want to come back for just a minute to the prospect of regulation, because as you know, DOJ and FTC have been very interested in these issues for a long time, and the Federal Trade Commission is in the middle of looking for new targets for regulation. So I mentioned contact lenses, and there's a contact lens rule, and there's a funeral rule, and there's an eyeglass rule. And so the question that I would have in my mind is whether there could be a real estate rule that basically says, look, knock it off. It's like, we're not going to do this unilateral offer of compensation. Now, to be clear, this would be a big change for the real estate industry.
Yeah.
But it is an area where the agencies have developed some expertise over time, which is the kind of place where they might well act. It's a pocketbook issue. It's a highly, of course there are big brokers, but still the players, as you just noted, are quite numerous. And so, doing case after case after case after case, it may not be the best way of accomplishing change. And so if you see an anti-competitive outcome, and I think there's evidence that we have a poorly functioning market here, regulation, for example, in the form of a real estate rule, is something that I would expect, for example, the Federal Trade Commission to take a careful look at, given that what they are doing right now is looking for an attractive target for regulation.
I didn't know that. Okay. Be warned.
It was announced a couple of months ago that Acting Chair Slaughter has put together a group to find suitable subjects for for rulemaking.
Well, and it just occurs to me in 2021, I mean, housing and the insanity of the housing market has to be politically significant. I mean,
Yeah,
yeah,
I think
okay.
doing something in this area, I do think is good politics.
Yeah, yeah. All right.
Just I'm repeating what you said. Yeah.
So from that, I mean, you know what? Let's get into it real quick because I do want to talk about some of the other cases
Yeah,
confronting us
sure.
as well. Um, do you think the FTC, or maybe just generically speaking, the federal government, would take into account that any sort of, say, real estate rule that prohibits cooperation compensation, right? In other words, the practice of the listing broker, listing agent paying the buyer agent, buyer broker, that would essentially destroy the real estate industry as we know it, number one. Massive, massive disruption. And number two, if these cases, Moehrl, Sitzer, any of these things, if any of them turn out as victory, then the amount of money damages involved would bankrupt literally everybody in real estate right now. Like, do regulators, do policymakers take that into account as they're thinking about the
Yeah.
rules?
Yeah, no, it's a great question. I think they would have to,
Okay.
right? I mean, whether or not they say they do, I think they'd have to. Um, and reliance interest sometimes matters kind of on the margins and thinking
Mm-hmm.
about um, the right antitrust rule. Let me distinguish for a minute, the private case like Moehrl
Mm-hmm.
and an FTC action, because their implications for financial damages, of course, could be pretty different, right?
Right.
You could imagine a regulatory solution implemented by the FTC that would not, of course, by terms require any, payment for previous transactions where the rate was too high.
Mm-hmm.
Um, I'm not predicting legislative change, but of course, congressional action would also have the implication that
Right.
um, damages wouldn't follow. So, to the extent that damages are a piece of the puzzle, that might lean in favor of regulation as against private
Mm-hmm.
litigation. But to take your first point, it is certainly the case that either of them would produce certainly substantial disruption to the
Yeah.
way, things have been done. My suspicion is that by itself is not a deterrent. It's a concern,
Mm.
right? It's something that would need to be taken into account. But if the organization of the industry has something kind of anti-competitive at its core, then still there would need to be an adjustment. I mean, I'm sure
Right.
that for optometrists and ophthalmologists being forced to hand over the prescription, which was the way that they were thwarting price competition on the contact lenses, that was highly disruptive. It was probably a negative, probably a substantial negative for their business, but that
Mm-hmm.
didn't by itself stand in the way.
Right.
Um, so that would be my initial reaction.
Okay. So let's move on to the other case. There's two other cases
Yeah.
I just want to ask you about. One is the rebate thing, because you mentioned you didn't seek a rebate. I know there have been, and so step back. There are certain states that have prohibited rebates by real estate brokers and licensees. A lot of them were actually sued by the government. I think the Department of Justice and the FTC, both of them, talk about how they will bring lawsuits against states for these rebate bans. And there have been some private cases. The most recent one is Rex, that you've mentioned you do some consulting work for. They, I believe, have sued the state of Oregon, right? Um, what do you think the prospects of that are?
Yeah. So let me back up again for a
Yeah,
sec,
of
because
course.
when you asked if there's anything else I wanted in my bio, uh, one thing from sort of personal history that's worth sort of bringing out is, when I did the public service leave that you mentioned and
Mhm.
led this team in New York, bringing cases and investigations, one project that we had was to think about the state of rebating in New York.
Mhm.
And so this was 2012 more or less,
Mhm.
and we discovered to our surprise that people thought that there was an ambiguity in New York law as to whether rebating was legal,
Mhm.
and it turned out that standard broker training included the assertion that rebating was flatly illegal, which was certainly not our view, and it's certainly not the case now. And so one of the things that we got started and that came to fruition after I left was to change the statute to make absolutely clear, I got the language in front of me, that nothing in the section shall prohibit a real estate broker from offering any part of a fee, commission, etc., received by the broker to the seller or the buyer or what have you.
Okay, right.
But we do face this prospect that in a few states, the law might be arguably ambiguous, right? I mean, I think the typical situation seems to be one in which the statute says, you can't give any money to somebody who's unlicensed. And what they, I'm misrepresenting the statement a little bit, but the primary focus, maybe the sole focus, was I think obviously to make sure that unlicensed people aren't doing real estate work that requires a license.
Right.
The central point in none of these was that the buyer themselves can't be given a rebate. Like that's not what these have in mind. And so the question is whether you can stretch it, whether it's a fair reading, whether it's the right reading. And under pressure, the states, when asked this, their state boards have tended to say, you know what, we didn't mean that, right? And so we have situation after situation where, when put to the test, the state blinked and took the pro-competitive route of saying, no, we really didn't mean to rule this out.
Right.
Now, suppose that's not what happens, right? Suppose the state board sticks with this provision, with this anti-competitive interpretation. It says, no, this is what we meant, right? So then we basically are left with the question: are two requirements satisfied? So in order for an anti-rebate law to stay on the books, it needs to satisfy two things. First, that the state policy of thwarting competition is clearly articulated. So the idea here is that antitrust law should prevail unless the state really means to stick to its guns. And it should shout it from the rooftops, because then it becomes a salient political issue and the political process can take its course, right? Pocketbook voters might say, you know what, I think this is a terrible rule. Let's get rid of these guys, or let's press for a different political resolution. Right. But so it has to be clearly articulated. And where a lot of these founder is that it's not clearly articulated because it's mushy language that is best read in a different way. On the one hand, that provides an out for avoiding the anti-competitive problem. On the other hand, it makes it harder to stick on your anti-competitive principle if it wasn't clearly stated to begin with. And then the second requirement is that the state law needs to be actively supervised. That the anti-competitive scheme needs to be actively supervised, so that whatever it is that you're trying to accomplish, you're actually managing it, that the state actors are managing it. And so if you leave the scheme in the hands of private actors, which is the case for a lot of these boards, that's going to create a problem, and it's going to tend to lead to a judgment that what was done was anti-competitive. So
is there an example, it's like some other industry where we've seen this, where the state says, oh no, we definitely do not want competition and we're actively managing it?
Yeah, so the classic situation is in healthcare, where states become concerned about how many hospitals there are and where they are located. And if you think that there's too much competition between two hospitals, you might think, you know what, maybe we could run more efficiently or better take care of patients, you may believe this, by permitting a merger. And so, we do have situations fought bitterly by the Federal Trade Commission. They don't like these, right? They think that competition is the right way of accomplishing high quality, low cost healthcare. But it could be a political judgment to do something different. And so you will have states that will explicitly say, through certificate of need type laws, that we're going to manage, maybe micromanage, the location and size of hospitals, even if that leads to outcomes that an antitrust economist would think of as being problematic. Right. So I think that's the classic situation.
But it's explicit, and to your point, it's actively managed. Okay.
That's right. It's explicit.
And just little legal nerdery here. When the state provides a justification, what is typically the kind of the standard review that the courts might use to look at those justifications?
Oh, I see.
Is it like rational basis, compelling interest?
Yeah, I don't have that at hand. I
Okay.
mean, it tends to be a question of specificity rather than justification,
Okay.
right? So, like, I don't think the fight is centrally about, well, you said you care about patient quality, and we don't think that reason is good enough.
Right.
It tends to be more, you said something mushy, and we want you to say it clear enough for everybody to understand what you're up to if
Okay.
you were going to suspend the rules of antitrust law.
Okay. So it feels like it's at least like a step above rational basis, where it's just like, hey, if you can come up with a rational reason for why you're doing it, we're going to allow it. Seems like it's
Yeah,
at least a little bit more than that.
Yeah, I think I'll just to come back on this. I
Yeah.
think of it less as sort of rational basis versus strict scrutiny, like the degree of inquiry,
Yeah.
and more like clear statement rules that we
Mm-hmm.
see in other contexts, where if you want to, take advantage of some kind of privilege, it needs to be
Right.
clearly stated.
Okay. Okay. So the Oregon case, with that in mind, which direction do you see that going? Has the FTC intervened in that case? Do you know?
I don't know the answer to that. And
Okay.
again, I'm not gonna offer a guess with respect to this.
I keep trying to get you.
I know. It's, yeah. I mean, it's certainly the case that the trend in the country is toward sweeping these rules away, right? We see fewer and fewer states. I think it's like a dozen, maybe 10 laggard states that haven't taken this off the books. And you can see going back to the 80s and since then, steady reduction in the number of states that do this as consumers to some degree wake up and seek out rebates, as companies have business models
Right.
that rely in part on rebating the buy side commission. But this isn't an entirely new issue, right?
No, this has been going on.
There's a fun set of cases from the 80s where I think it was, I mean, I'll get this mostly right, but Caldwell, right, which was at the time a unit of Sears, they'd basically act in conjunction, and Sears would basically have coupons
Yep.
for home appliances if you'd done the residential deal with Caldwell.
Yeah.
And various states were up in arms that this was a violation of the rebate rules, and these got challenged in state after state.
Yeah.
And the states backed off in the face of the challenge.
Yeah. Last big case. Well, again, which is so weird. It also involves Rex, and it's like for such a tiny little brokerage, boy, they're involved in some lawsuits. Zillow, Rex versus Zillow. Right? This one, it's a little odd to me because so we all understand. I mean, the idea is that Rex is suing Zillow, suing NAR, suing MLSs, saying the IDX anti-commingling rule, right, is anti-competitive. What was weird about that case for me, there's a couple things. One is, to me, because just as an industry guy, Zillow is as much a victim, right, of that rule as Rex is. And yet Rex sued Zillow. Like, why? Like, why couldn't they work together to go against this rule? Is there something I'm missing there, Professor? Like, what am I missing?
So I should say, with respect to this one, this is a case that I'm involved in as part of my as part of the assistance I've been providing to the company. So I just want to be clear. This is one that I'm more deeply engaged in than the other matters that you've mentioned. I guess I'd say a couple of things. First, when you think of a case that's being brought under Section 1 of the Sherman Act, which renders unlawful combinations of conspiracies in restraint of trade, it takes two to tango, right?
Okay.
That you need multiple parties in order to have a Section 1 violation. And what the case is alleging is that Zillow's agreement to join all of these MLSs and to get wrapped up in NAR is an unlawful restraint of trade. And as you say, I mean, Zillow positions itself as a victim here, right? To the extent that they agree, apparently, with the plaintiff that the rule in question is anti-competitive. However, you can be a party to a restraint of trade that you dislike or disagree with. Let me walk,
Okay.
take us back a little
Talk
bit
to
in
me
history.
about that. Yeah.
Yeah. So, Microsoft, right? Microsoft got in a lot of trouble in the 1990s. That trouble persisted into the 2000s for various agreements that it had reached with, among other things, PC manufacturers, right? And the PC manufacturer had basically said yes to various restraints that the government alleged made life harder for independent producers of browsers, notably Netscape, to thrive, right? Thereby protecting the Microsoft's operating system. Now, some of the conduct that was alleged was unilateral, that Microsoft had just done that moat building that I was talking about before. Some of it was a Section 1 claim that their contracts with these PC manufacturers were unlawful. The PC manufacturers hated the contracts, right? Hewlett-Packard kind of famously said to Microsoft that if we had a choice of our trading partner, you would not be our choice. I mean, they hated being restricted in these various ways.
Yeah.
That doesn't get you out, though, of the existence of a Section 1 violation.
Okay.
And so, to take another example, in one area of antitrust doctrine called tying, it is commonly the case that one of the parties to the tying contract is the purchaser who wished they weren't stuck with the tying claim. So, reluctant joiners, coerced joiners, they're still joiners. So, the liability here doesn't turn on Zillow's protestations about being a victim. I do think the fact that they appear to agree that the conduct is anti-competitive, is important and confirming of the competitive problem here. But I don't think there's any sense in which it's exonerating.
Okay. So in like the Hewlett-Packard case, though, I mean, shouldn't the plaintiffs at least treat them differently? Do you know what I mean? I don't know who brought that case. Was the Department of Justice that did? I mean,
I take the point.
Yeah.
I mean, I take the point, and in the government's case against Microsoft, Hewlett-Packard was not also sued, right?
Okay.
So this would be to your point of there being, of there being a distinction.
Yeah.
I think, be it as it may, I think one question here is, do you see a benefit, right? I mean, because you're basically asking, put the law to one side. Isn't it better? Isn't it better business? Might it be better policy to decline to sue a firm if the firm is only a victim? Even granting that they're a party to an anti-competitive contract, maybe you in the exercise of discretion don't sue them.
Yeah.
I think one question that arises, right, when you're trying to decide, and this comes up in a lot of antitrust cases, is does this victim see some benefit? Because I mean, Zillow's an adult, right? They're not some shrinking violet that knuckled under. At least in their own telling, it wasn't that they knuckled under the MLS. It was that it was, a regrettable cost of doing business in order to achieve the benefits that they wanted to achieve.
Right.
But I mean, to say, look, we got a lot of other things, is also not exonerating, right? I have no reason to doubt that access to IDX feeds is better than the piecemeal access that they previously had to all these individual MLSs, that you would prefer to have the fire hose of IDX to other ways of doing it. But that's not exonerating. It's at most an explanation of how they got mixed up in this. Right. But it's not at all exonerating vis-a-vis the target here, which is not the MLS, just to be clear. It's this specific unjustified, as far as I can tell, unjustifiable rule, right? I've not seen any effort to justify this rule so far.
No, right? I haven't either. However, let's move to the second
So this
one.
should be easy, right?
Well,
Just get rid of the rule.
But here's the thing, though. The second part is, and this is both NAR. I think this was NAR's strongest sort of defense, if you will, right? Is first of all, there's no conspiracy, but you've kind of dealt with that. The second one really is this is an optional rule, right? This rule, the non-commingling, is an optional rule. Why are you suing us, right? Go sue the MLS. Like, why is this our problem? Like, I mean, that seems pretty fair to me. It is an optional rule. Why are you suing NAR?
Yeah, I mean, I think the MLS is. So I don't want to speak for plaintiff on this. I mean, the MLSs are implementing these rules, pursuant to the set of things that are pointed out to them in an NAR rule book, right? And so, I mean, let's imagine that NAR had suggested that an optional price would be 6%. Okay. We're not saying 6% should be the unilateral; it should be the total commission. But at your option, go ahead. Okay. I don't think anybody would let NAR off the hook on the ground that they had said, "Oh, but this was at your option. We're just putting out a sort of discretionary number that then gets implemented by, let's say, most, albeit not all, of the MLSs." Mm-hmm. I don't see why that would be a controlling defense. I mean, it's an agreement by NAR. I mean, NAR represents an agreement among rival brokers that does contain this rule book. And yes, it's certainly true that some of the rules are mandatory and some of the rules are optional, mm-hmm. but they are still rules that are promulgated under their authority and then get implemented by these MLSs.
Okay. So this leads to yet another policy question. And and again, I understand you're not necessarily intellectual property policy background, mm-hmm. but you do have the antitrust, you do have, and I'm sure you've dealt with this, and this is now, the way I look at it, the current state of antitrust law is probably much more concerned around, information, intellectual property, data, because obviously Facebook, Google, these guys are like the focus of most antitrust inquiries and whatnot. At what point, I guess, do regulators or does the government step in from a data standpoint because of these types of problems? In other words, all of these problems exist because the industry, through NAR, controls IDX, controls real estate data, right? And the MLS controls real estate data. For the longest time, I've been concerned as an industry insider, like, if we don't fix this, if we don't solve this ourselves, I felt like the government would step in. Is this a legitimate concern, I guess is my question.
So what do you have in mind in terms of a data regulation, I guess I'm asking?
Literally a governmental data utility. Because back in the 90s, there were, not 90s, 2006, when the Congress held the hearings, there were people going on Capitol Hill saying the MLS should be a public data utility and should mm-hmm. be regulated that way. And mm-hmm. the industry said, hell no, this is a broker cooperative. We don't need more regulations, get out of our way. It never happened. Okay, well, here we are 20 years later, and we're having the exact same conversations. So that's what I mean.
Yeah, I mean, certainly it's true that to the extent an MLS is a kind of essential facility or something that has a kind of natural monopoly mm-hmm. feel to it, those are the prime candidates for regulation. And so, thinking of it as an economist, it's the kind of place where you would tend to expect to see regulation introduced. Mm-hmm. I'm not a close Congress watcher, but I have suspicions about the ability of, that in this closely divided political environment that we're in, there being the will to change the law, mm-hmm. right, in order to accomplish something like this, even if a lot of people agreed that it would be desirable. I mean, coming back to antitrust for just a minute, though, it is the case that sometimes you see, dominant exchanges, dominant centralized mm-hmm. utilities used by competitors coming under the antitrust yoke. Maybe not simply by virtue of their dominance, but they engage in certain conduct that turns out to be problematic, and then the antitrust decree then enables the court to manage questions like interoperability in a way that promotes dissemination of the information, right? An example that comes to mind, it's a little bit distant, is ASCAP and BMI, these performance rights organization. If you play a song on the radio station is, licensing the music from ASCAP and from BMI. Now, ASCAP and BMI operate under detailed consent decrees with the Department of Justice and have since the 1940s, in part because they are this centralized repository of, all the world's music from the standpoint of a U.S.-based radio station. Antitrust law and a couple of judges in New York City manage those terms of trade. Because otherwise, this combination of competitors raises antitrust concerns. And of course, NAR has for years been under various antitrust consent decrees, partly for this reason. And so you could imagine, perhaps, to say it's a private ordering solution is a kind of an exaggeration. You could imagine that in the context of litigation, a consent decree, providing provisions for access.
Okay. Yeah. I mean, this is like one of the things we've been fighting over in the industry for the last 20 years, right? Data access. Because until the internet came along, this really wasn't a thing, right? The real estate data was not something that brokers and agents spent a lot of time talking of and thinking about. Well, ever since the internet came along, this is now, topic number one, almost everywhere. And I just keep wondering what's going to happen,
Yeah, I mean, from that perspective, this Zillow case is sort of one to watch. It's not the same, obviously, as DOJ bringing a case to simply mandate IDX fees to all comers. I'm not suggesting that is something that DOJ would be interested in. But to the extent that Zillow was open and then it became closed by virtue of joining all of these MLSs and coming into concert with NAR, you could see that as a partial solution or a partial response to the data concerns that you're raising.
Right. And like I said, I mean, that lawsuit specifically, who knows? I'm curious to see how some of the motions get ruled on, but it's just more the policy side, I think, on that one that I'm much more concerned about. Because the only place where I will comment there is, I don't think it's the federal government that needs to take action there. Because again, the highly divided Republicans and Democrats can't possibly agree on something like that. I'm thinking it could happen at the state level. And the state legislatures are much more united. So you could imagine like California, which is, it's pretty much a Democrat state. They could easily say, you know what, we're going to create the California Property Information Repository, right? And regulate it that way, not necessarily through the federal government, at the state level, or Alabama, which is mostly Republican, so something like that is what I'm more concerned about. And realistically, I think there's more of a chance that because we're talking about real estate data and a state has to be fundamentally really concerned about real property within its borders, I can see a real strong claim that we need to have better data and we're going to do it this way. That's what I've been concerned about. And it's lawsuits like this one, like the Zillow one, that makes me go, all it takes is like, I don't know, the New York Attorney General looking at this going, wait a minute, this is a problem. Why don't we have data? Let's just go force these guys, regulate them to give us data. I mean,
right. Although I do want to say, I mean, having the New York Attorney General be interested in something has historically not necessarily meant that the New York legislature and the governor want to go along. They're not always on exactly the same page, at least in the state of New York. They're both elected officials, and sometimes more rivals than buddies.
Excellent point. All right. Finally, I think I wanted to just kind of briefly ask and touch on the NAR DOJ simultaneous lawsuit settlement consent decree thing. I mean, at this point, we kind of know what the result was. The question I had for you, especially because you have such a strong economics background, Scott, is do you think this would make a difference? In other words, let's remind everyone, what the agreement was that NAR would now make 4 changes. One is you cannot allow searches by compensation offered, right? Second one is realtors can no longer claim that buyer services are free, right? They have to say, no, like this is what it is. Third, that you cannot limit brokers from displaying compensation amounts, right? So now Redfin recently in the earnings call said so. We are now going to put the cooperating compensation on every single property, right, on Redfin.com so consumers can see it. And the fourth one is lockbox access, right, which is whether you're an MLS or association member or not, you have to grant some way of granting access to lockboxes. The last one I think is relatively easy. The thing that I'm curious about is the consumer awareness side.
Yeah,
right?
It's a great question. It's a great question. I honestly don't know the answer, right?
Okay.
I mean, as an economist, I'm supposed to believe, I'm sort of trained to believe
right.
that given excellent access to information, consumers will, make good decisions, and good, sometimes in this fairly arid, simplified, dumbed down, they'll find whatever's cheapest, which obviously is not the only thing that a consumer is going to care about. I do think that stopping this practice of saying that it's free to the buyer does make a difference.
Okay.
That it will make a difference.
Okay.
That's believable to me.
Okay.
I think there's more to be done here, though, because I think there's still a huge lack of information on the part of buyers. That when a buyer is in the process of doing buying, they're just, for the most part, not aware of how this actually works. They don't think it. They're not fully aware that this is ultimately, in fact, coming out of their hide. And so, what would help? I think one thing that would help would be better information about the degree to which real world buyers right now are paying less than you, buyer, are. That is, to know that several thousand buyers in New York City in the last 6 months have saved an average of whatever it is, $15,000. New York's an expensive market,
right?
By using one of these rebating tools, let's say.
Right.
I think that would make a difference. And I don't think that information is available right now. So I think knowing that it's not free is part of the puzzle.
Okay.
And also knowing that it could be cheaper and that other people are getting good deals.
Okay.
Right? That people do bargain, or that people do use these alternative tools. I think that is a cheap and cheerful way of improving the degree of competition in the market.
Okay. I was just curious.
That builds on what the government accomplished in the settlement.
Yeah. No, it's just when you were talking about that, almost immediately my mind went to Edmunds, the car website where everyone's constantly comparing. Hey, what's the deal you got on your whatever, right? BMW 3
Yes.
Class.
No, exactly.
Something like that is what immediately came to mind. But people buy cars like every other 3 years or so. Especially with leasing. Houses, we're talking about something once every 7 years, maybe, if not longer. I guess that's. But so you kind of answered my question. I was just wondering, do we think consumers will really do this, right?
I mean, when people buy, they certainly care about comps for other houses in the neighborhood. They know to look at that. So it doesn't seem crazy to me that an additional piece of information that they would find salient is, by the way, some people find another $8,000, $15,000, $4,000 to put it on their offer because the buy side commission has been rebated them to them in some way that then can be thought of as an expansion of their purchase power.
That's a really interesting point. All right. Well, that's almost all my questions. This has been so useful, so amazing. Let me, maybe as a last sort of parting question. And I saw this on a lot of podcasts, and I love this question. What do we not talk about that we should be talking about?
Oh, let me think about that for just a minute. I mean, I guess the only sort of major thing that I think bears repetition is, it brings us back to Zillow just a little bit, and it's the importance of keeping open inputs open. And I mean this. We talked a lot about price, and that's important. But I think innovation is important too. And in Zillow has historically been a tremendous innovator.
Yeah.
Right. And viewed from outside the industry, I think there's a lot to commend them for. And part of why Zillow is able to be Zillow has been the availability of data. Okay, sure, it wasn't IDX data, and sure, they had to bicker over it and update it and fight, engage in hundreds, maybe thousands of little negotiations to get the data. But they got the data, and they themselves were open, which allowed further innovation by Rex, by others, on top of that platform. And openness has a lot to say for itself as a seedbed of innovation. And so, from where I sit, it seems important that we keep in mind the importance of open interfaces and interoperability in order to enable these kinds of innovations that ultimately are to the service of home sellers and buyers all over the country.
All right. Well, thank you. No, that's an excellent point. The whole open innovation environment. I know that's something that MLSs do talk about from time to time. Brokers talk about it, but they don't actually ever do anything about that. But hey, whatever. Maybe we'll see a change. And it's not just money. It's not just price. It's sometimes just innovation that we haven't even thought of, like stuff like iBuyers, which is super innovative. It could not have happened without data, without public records, data, without MLS data, without comps data, without some of the stuff that's been developed. All right. Well, Scott, Professor Hemphill, thank you so much. This has been such a pleasure. And hopefully,
thank you for having me.
Yeah, hopefully it was even remotely interesting for you as well, because real estate
engaging.
antitrust, is not exactly the most.
But I disagree. It's really cool.
But I look at it as like, boy, if you're not from the industry, if you're outside of this, you probably could not pick a more boring topic. For us, it's super interesting. This is. You
better edit this part out. You're not.
It's at the end. It's at the end.
This at all.
If they're watching this, they've already listened to everything.
Right. If you've made it here.
But thank you so very much.
Yeah, sure. My pleasure.
All right. Take care now.
Have a good one.
All right. Bye-bye.
Bye.